Archiving started.
Welcome back to our fourth presentation on Chapter 4, the chapter that talks about the sources of American law. For the last several presentations, we've been focusing on the common law tradition, or case law, and now we're going to flip ahead to the Constitution. You may, before we talk about this, I'm going to clear the slide for a second. You may recall we talked about primary sources of law at the very beginning, and we listed 4 examples of primary sources of law. And those, the first one was going to be case law or common law. That is usually considered our first. It's not more important than the others, but just kind of, we got to list one first. So we're going to list common law first. So I'm going to say common law / case law. Well, we can check that off. And that's a good one to check off because, honestly, the most stuff we have to think about is going to be on this one. So I'm putting a little check here. Our next is going to be the Constitution. So state and federal, that's the next one we have to check off. And then we have statutes to talk about. The reason why we list the Constitution first is that the Constitution, both state and federal, establishes what can be done with statutes, what the parameters of statutory law can be, and then finally we talk about regulations. This is also sometimes, when we talk about statutes, we could also call this codes. And regulations, this is oftentimes called administrative law. So I'm giving you some synonyms, so when I use a term, you'll have a point of reference to make sense out of it. Okay, so we're going to talk about number 2, and then subsequently we'll talk about 3 and 4. So we're up to constitutional law. I'm going to go back to talk about Constitution. Our federal Constitution, the U.S. Constitution, was ratified in 1787. But for the 6 years prior to that, we actually had a different type of governing document. It was called the Articles of Confederation. And you probably remember hearing about this when you were studying American history or perhaps in your American government course. Now, of course, the victor gets to write the history, so nowadays when you hear people talk about this, they will say things like, well, the Articles of Confederation were too weak, it didn't give the federal government enough power, and it was going to cause a lot of problems and was causing a lot of problems for the United States, and so therefore the U.S. Constitution came in. It had a much more robust centralized government, and it was much cooler and better, and rah, rah, rah. We're so glad that the U.S. Constitution prevailed. And that's a very defendable argument to be made. Of course, at the time, in the late 1780s, there were lots of people who supported the Articles of Confederation and thought that the idea of a U.S. Constitution was a bad idea for lots of reasons. And so you may recall the Federalist Papers talked at great length about these topics, and people of goodwill and good faith and earnestness had differing opinions on this. But, of course, the Constitutionalists won, and the Constitution became ratified in 1787. It's the system of government we have now. Whether or not it's better or less good than the Articles of Confederation is an interesting issue to debate, but as a practical matter, the Articles of Confederation are no longer in effect. But let's think for a second about what our Founding Fathers were thinking about when they established the Articles of Confederation. Well, back then, I'm going to make this go blank for a second. Back then, I'll do one of my awesome pictures of our country's shoreline. There's a series of colonies here. As you can see, I'm very, very good at drawing these. Each one of these, let's say we'll call this one Virginia. If I lived in Virginia back in the 1700s, I probably rarely went to North Carolina, if ever. I probably rarely went to Maryland, if ever. I may never have left my colony. Roads weren't very good. The means of transportation weren't that awesome. And so the odds of me traveling far from my home, probably not very significant. The people that I knew were Virginians. The government that I was used to was Virginian. And, of course, back when my country was a colony, my colony would interact with Great Britain, but didn't have that much interaction with other colonies. In fact, one of the things that Great Britain wanted to be kind of the clearinghouse back and forth. So if Virginia was going to deal with Great Britain, but not deal so much with the other colonies. I don't want to act like they never had any involvement, but certainly colonists identified primarily by their colony, not so much having an idea of being an American or being part of this United States of America. And this continued even after the American Revolution. So when the Articles of Confederation were adopted, the idea was that my primary identity was going to continue to be as a Virginian. Yes, I was a citizen of the United States of America, sure, okay, and I had some loyalty there, but primarily my identification was as a Virginian. Now, this sounds a little funny to us now, maybe not so much those of us who are Texans, because we have some of those aspects of our identity as well. But for most states, yeah, if you're from Wisconsin, you like Wisconsin, but you mainly consider yourself a U.S. citizen. But this wouldn't have been so much the case at the time of our nation's founding. Let me go back here and go to this slide here. So the Articles of Confederation established very strong states and very limited power for the federal government. But it's hard to have a national defense. It's hard to have a coherent foreign policy. It's hard to raise taxes and legislate on a national basis when you have such a weak centralized government. Another reason that the Founding Fathers sought to have this Articles of Confederation versus a more robust central government is that, of course, our Founding Fathers were very annoyed with Great Britain. And they saw Great Britain as a centralized power that was exerting a lot of unfair rules and taxes upon the people. And so their concern was if we had a centralized national government, what was going to stop it from doing the same things that it felt Great Britain had done to the colonies? So it wanted to avoid that by not having so much centralized power. So that was kind of the philosophy, but as I said, many of our leaders found that the Articles of Confederation, though nobly planned with the best of intentions, didn't actually bear the fruit that they wanted. So when the U.S. Constitution was ratified, it created a much stronger national government. But still, these were the same people, after all, only 6 years had gone by, that had once fought with Great Britain. So even the people that were supporting the U.S. Constitution had many of the same concerns that the founders had at the time of the Articles of Confederation. They were concerned about an overly strong central government, too, and so they addressed those concerns through the document that became our U.S. Constitution. And the Constitution, I like to think of it as, here, let me give an example. Here we go, as kind of, oops, that's not a good example, as broad brush strokes. You don't look to a constitution for minutia, for details. It's a bad constitution, honestly, that gives you a lot of granularity, tells you, for example, how much the governor is going to be paid or what the address of the president ought to be. Because after all, with inflation, whatever George Washington earned as a salary, it would be ridiculous for even Roosevelt to be, or Woodrow Wilson to be paid, and certainly it would be ridiculous for whatever Woodrow Wilson was paid as president to be what our current president is earning. So you need to adjust those expectations over time to reflect the realities, the technology, things like that. You want to have a document that's going to be timeless and that's not going to need to constantly be revised and amended to reflect changes along the way. So that's, from that perspective, you want to have kind of like a mission statement. You know, if you've been in a corporate organization or maybe even a club, many times those organizations will establish a mission statement. What are our guiding principles? What are we trying to do here? And you're thinking kind of abstractly, kind of in general terms, but the hope, the idea is that once you establish these, you'll be able to refer to it and keep yourself on track of kind of your North Star, where you're always pointing to in terms of direction. And so our federal Constitution talks about the general organization of the federal government, the powers that the federal government has, and, at least as important, were the limitations on the federal government. An important clause in the Constitution is the Supremacy Clause. You don't need to know where it's found, but you do need to know the Supremacy Clause exists. And what it says is that the U.S. Constitution, the federal laws, and the treaties are supreme over the states. If the United States government and the state of Virginia get crosswise of each other, the United States government is likely to win that dispute. And, of course, this is a new idea. Wouldn't have been something that would have been well accepted into the concept of the Articles of Confederation. But there's a balance to the Supremacy Clause, and that is that the powers of the federal government are enumerated. And when I use the word enumerated, I mean they're specified, they're listed. And so if the federal government has the power to do something, if it can point to a provision in the Constitution that says, yes, we get to do X, then it's supreme. But if a provision in the Constitution doesn't exist, that the Congress can't say, okay, this is how we get our power to do whatever it is we want to do, then it can't act at all in that area. So it has to find something in the Constitution that empowers it to act. If it can't find it, then the power resides in the states and Congress can't do anything. So it's a balance. The Supremacy Clause and the requirement that the power be enumerated creates that balance that we find in the U.S. Constitution again and again. An example of this premise is, for those of you all that follow politics, is the Affordable Health Care Act, which is oftentimes called Obamacare. And you may recall that at one point there was a question about whether this was going to be held to be constitutional or not. You may have wondered, if you didn't follow the news carefully, well, what would be the basis for it being unconstitutional? Well, the claim that people who opposed the law, or at least opposed or felt it was unconstitutional, were that there was no provision in the Constitution that gave Congress the authority to establish something like the Affordable Health Care Act. And one of the things they pointed to was that while Congress has the ability to regulate commerce, what the Affordable Health Care Act did was something different than regulating commerce. It was actually requiring that people participate in commerce. They had to buy this insurance product. And their argument was that requiring people to buy it is different or more than regulation. So they would say that there is no enumerated power that gives Congress that authority. Well, the U.S. Supreme Court found that, in fact, the Affordable Health Care Act, or at least most of the provisions, were constitutional. Although they didn't find that constitutional authority within the Commerce Clause, they found it in the taxing authority of the court. But the specifics of that case aren't that important for the purposes that I'm trying to make here, but just that whenever Congress acts, it has to be aware that it needs to be able to point to something in the Constitution for that authority. Here are the articles in the Constitution, the body of the Constitution. This is from the textbook. I definitely don't require that you commit this to memory, but it's kind of useful to see how the document is organized so that you can find a particular provision that you might be interested in. So we're going to continue talking about the U.S. Constitution. Let's talk about the Commerce Clause. This is a part of the Constitution. We haven't yet got to the amendments yet. And this is that language. The Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes. This is the power that Congress initially asserted it had to legislate in the Affordable Health Care Act situation. This gave it its power. The Commerce Clause has an interesting history. If we were 150 years ago, if we were having this course, we would have had a very narrow interpretation of what the Commerce Clause was about. It was among the several states, meaning commerce between the states, not so much commerce that happens in the states. And so back, say, 150 years ago, states were the primary regulators of commercial life. But at the time of the Great Depression, when the New Deal under Roosevelt was being developed to help us get out of that terrible time, Roosevelt advocated for, was able to eventually persuade the Supreme Court to have a much more expansive definition of commerce. And as a result of that, a change in philosophy, since the time of the Great Depression, say from the late 1930s through, I would say, 2000 or even a little bit later than that, the scope of, and the power of the Commerce Clause has been interpreted more and more broadly. My area of practice was employment law, and almost all of the statutes that I dealt with professionally, the federal statutes I dealt with professionally, the basis for that authority would have been found in the Commerce Clause. So this is a hugely important shift in our court system. But we can see under the Affordable Health Care Act precedent that the U.S. Supreme Court has somewhat narrowed the scope of the Commerce Clause. Certainly haven't returned to the era of 150 years ago, but probably if it was initially this big and it got to be this big, say, in 2000, well, this court seems to be making it a little bit more narrow than it was before this. So we'll have to see how the law develops in this area. It's going to be an interesting time. in the development of jurisprudence when we're looking at the Commerce Clause, especially in the next several years. This, as I said before, the Commerce Clause is the mechanism by which most federal legislative power is created these days. And the standard is, the federal government could legislate in any area as long as commerce substantially affected commerce across the state line. And this substantially affected was a very weak standard. Virtually everything got to be regulatable if it was related to commerce, even if it didn't seem to have a very strong interstate component. And in some sense, this makes sense. Back when we were a rural country where people rarely traveled out of their state, when I'm in the state of Virginia and I am buying things, the food I buy was probably made in Virginia. The cloth I buy was probably manufactured in Virginia. The stuff I sell on my farm is probably sold to Virginians. There isn't a lot of interstate commerce that the average person was probably involved with in the 1700s. And so it made sense to kind of tell Virginia, hey, Virginia, why don't you manage your own economy? Because after all, it's really kind of distinct and separate from the economy of North Carolina or the economy of Maryland. But nowadays we have an economy that is very both interstate and international. The clothes that all of us are wearing today almost certainly have some products that originated in a foreign country. When we are performing services as paralegals, we almost certainly will be having clients who live in other jurisdictions or who are incorporated in other jurisdictions. So we find with the increase of travel, the increase of trade, the internet, things like that, there's so much activity that crosses state lines, it no longer makes sense to think about this being a state-driven process, because if I am in Virginia and I am going on the internet and I'm buying something in California, and Virginia has one set of laws and California has a different set of laws, it's difficult to know which set of laws applies. But as I said before, this trend is somewhat, I don't say reversing, but at least not expanding anymore because of that recent decision. Kind of a big news that affect this. Another part of the U.S. Constitution actually passed after the U.S. Constitution was ratified, and that's the Bill of Rights. These are the first 10 amendments. The way I remember this is I have 10 fingers, and there are 10 amendments, and they make up the Bill of Rights. When we get to the 11th amendment, which exists, I don't have 11 fingers, so that's not part of the Bill of Rights. The first 10 amendments deal with the individual's rights against government power, and primarily, at least initially, U.S. government power. Again, it was designed to protect us from the federal government, not from our state government. And it does involve balancing rights. For example, we have freedom of speech, but I don't have the right to defame someone. I don't have the right to start telling lies about you and saying, oh, Bob is cheating on his wife, or Sally is stealing from the store or whatever. I can't tell lies about people. I can't knowingly make false statements. I have the right to have free speech, but I can't defame people. Similarly, I have the right to free speech, but I can't go to a movie theater and a crowded movie theater and yell fire and cause there to be a panic and people are trampled and people die as a result of that. I can't engage in that kind of behavior. So very few of our rights, in fact, I would say none of our rights are absolute. It's balanced against another interest that exists. And here are all the amendments that we're going to talk about here. The First Amendment is one that's packed with lots of different issues. We have the right, or at least the Congress, and you can see we start with the Congress shall make no law. So we're not talking about my state legislature or my Commonwealth legislature. We're not talking about the Texas Senate here. We're talking about the Congress, the federal Congress. It shall make no law as respecting an establishment of religion. So the federal government can't say, we're going to be a Methodist country, or we're going to be a Muslim country, or we're going to be an atheist country. But at least according to the First Amendment here, there would have been no problem with the state of Virginia deciding that we're going to be an Episcopalian state or Commonwealth, or we're going to become a Lutheran state or Commonwealth. This has to do just with the federal government. Also, Congress cannot prohibit the free exercise of religion. And again, this is focused on Congress. There's nothing stopping Virginia from saying you can't be a Baptist in our state. Of course, the Constitution of the Commonwealth of Virginia might well also precluded it from having an establishment of religion cause and prohibiting it from the free exercise of religion. But the federal Constitution wasn't going to tell Virginia what to do. So those are the two religious protections, and there's a lot of tension between the two. It's kind of beyond the scope of this class, but if you've studied much about constitutional law at all, you recognize that stopping the government from establishing religion and then also prohibiting the government from stopping people from practicing religion, there's definitely a tension between those two concepts. And constitutional scholars spend a lot of time talking about that and trying to figure out a way to make those two aspects of our Constitution work together.